It's like saying that consequential effect will follow. Something like that, my lord. If I may show, my lord, I have tried to frame, give copies.
There may be.
I have tried to frame in my own words.
You are saying that the consequences of registration of the marriage
The other side.
in different scenarios will arise.
Yes, yes, yes.
Arise.
But just kindly see, my lord, I have tried to frame it, subject to your lordship's pleasure. If I succeed, then I may get something like this. Are entitled to marry under the Special Marriage Act, regardless of their gender identity and sexual orientation. This is the main declaration. The court may be pleased to direct that the marriage will be solemnized under the provisions of the Act. This is an adjunct of item 1. The words
So the first three.
yes, yes. But my lord, I am more interested in 4. Have a look at 4.
I said 4 is a consequence of us.
Yeah, my lord, 1, 2, and 3 are really, my lord, paraphrasing the same thing. See 4. This I respectfully submit, my lord, subject to your lordship's pleasure. The court may be pleased to direct that all laws where rights, duties, obligations, and privileges flowing from marriage are conferred to a heterosexual couple married under the, sorry.
Yeah.
Same thing. But you are saying that you want a specific
Explicit,
declaration. So,
explicit, my lord.
according to you, the area of litigation should not be so wide that it creates a problem.
My lord.
And though you're confining it to the special marriage,
Yes,
you are saying whatever the
yes,
consequences of registration
yes, yes.
must be available
I
elsewhere.
am very grateful. My lord, we spend a lot of time in very carefully drafting,
Right.
my lord, within the contours. Because it should be explicit, my lord. Otherwise, every time, my lord, you start somewhere, you come up to the Supreme Court, 5, 7 years go by, our lives are in any case passing by, my lord, it becomes very difficult. I am not saying, my lord, that this struggle will end today. It can't end. But if we succeed, we should get an explicit declaration in terms of 4 or as modulated by your lordship, my lord, which flows from 1. Then, my lord,
Mr. Rohde, perhaps you may want to look at para 478 and 482.
yes, I was going to. My lord, I also wanted to read 472.
470.
It's very important. Very important because of the heading. My lord, see, deconstructing the heteronormative framework. I am again and again, my lord, hitting this part because we are being buried under the pressure of the majority. Wherever we go, wherever we stand, wherever we apply, I am buried under that, my lord. Oh, look, this is abnormal. What is normal is what is majority. But that is not the law, my lord. That's a mindset. That is not the law, but that's a mindset which is troubling us, my lord, in our daily lives. This is only an example to say public space, this, that. But that's what is troubling us, my lord. Therefore, my lord, the importance is deconstructing the heteronormative framework. This is what I am driving at. In the absence of a protected zone of privacy, individuals are forced to conform to societal stereotypes. Puttu Swami has characterized the right to privacy as a shield against forced homogeneity and as an essential attribute to achieve personhood. So I have that shield. That shield must be made explicit that I will not, my lord, be traumatized or stigmatized only because I don't conform to the heteronormative majority. Then, my lord, after the quotation of Puttu Swami, towards placetam F, this court has recognized the right of an individual to break free from the demands of society and the need to foster a plural and an inclusive culture. The judgment of 4 judges in Puttu Swami said this. Kindly leave this, my lord. Kindly come to 474 for a few words. The right to privacy enables an individual to exercise his or her autonomy away from the glare of societal expectation. The realization of human personality is dependent on the autonomy of an individual. In a liberal democracy, the recognition of the individual as an autonomous person is an acknowledgement of the state's respect for the capacity of the individual to make independent choices. The right to privacy must be construed to signify that not only a certain acts no longer immoral, but there also exists an affirmative moral right to do them. I rely a lot on this part because the immoral part is now gone. So the negative and the positive. That's how we have our constitution also have affirmative roles. Then there's a quotation by Richards. Your Lordship may then turn 478 and 479. An individual's sexuality cannot be put in boxes or compartmentalized. It should rather be viewed as fluid, granting the individual the freedom to ascertain his or her own desire and proclivities. The self-determination of sexual orientation is the exercise of autonomy, accepting the role of human sexuality as an independent force in the development of personhood, acknowledgement of crucial role of sexual autonomy in the idea of free individual. Such an interpretive of autonomy has implications for widening applications of human rights to sexuality. Sexuality cannot be construed as something the state has the prerogative. Because this is important. Let me read this right again. Sexuality cannot be construed as something that the state has the prerogative to legitimize only in the form of rigid marital procreational sex. This is exactly, my lord, the argument of the other side. Biological man, biological woman, their union is marriage. Marriage will lead to procreation. That is the order of nature and nothing more. That is exactly the argument even today. That's why I say, my lord, in some ways we are revisiting it. Because apart from criminalization, I still face, my lord, these problems. Sexuality must be construed as a fundamental experience through which individuals define the meaning of their lives. Human sexuality cannot be defined narrowly in terms of function as a means to procreation. So, my lord, not the narrow or a pedantic view. To confine it to closed categories will result in denuding human liberty of its full content and a constitutional right. The Constitution protects the fluidities of sexual experience. It leaves to consenting adults to find fulfillment in the relations, diversity of culture, among plural ways of life, infinite shades of love and longing. By criminalizing consensual acts who wish to exercise their right, state is denying a citizen the right to intimacy. The right to intimacy emanates from individual prerogative to engage in sexual rights, etc. Then, my lord, Shakti Vahini. That's important. Lord, I will not read Shakti Vahini because Shakti Vahini is quoted here. But my lord may note, my lord, on the side, there are three judgments. Shakti Vahini, Shafin Jahan, Lakshmi, and Deepika. I'll repeat, my lord. Shakti Vahini, Shafin Jahan, Lakshmi, and Deepika. These are four judgments which lay down and reiterate one principle, that every person is entitled to marry a person of his or her own choice. If it applies, Lord, to the heterosexual group or majority, I respectfully submit it will apply equally, my lord. To us, we may be a minuscule minority, but having the same rights are entitled to the same declaration granted, my lord, by this court in these four cases. Then, my lord, 480. In Shakti Vahini, a three-judge bench of this court issued a directive to prevent honor killings at the behest of Khap Panchayat and protect persons who entered into marriage that did not have approval of Panchayat. So Panchayat can be Panchayat, community, whatever you call it. The court recognized the right to choose a life partner as a fundamental right. The learned Chief Justice held. When two adults consensually choose each other as life partners, it is a manifestation of their choice, which is recognized in Article 1921. Such a right has a sanction of constitutional law. Once it is recognized, the right needs to be protected, cannot succumb to the conception of class honor or group. Then, Milord 481, Shafin Jahan. Shafin Jahan, this court set aside a Kerala High Court judgment which annulled the marriage of a 24-year-old woman with a man of her choice in a habeas corpus instituted by the father. The court upheld the right to choose the life partner. The Chief Justice held expression of choice in accord with law is an acceptance of individual identity, curtailment of that expression and ultimate action emanating therefrom, or the conceptual structural of obeisance to society will destroy individualistic entity. The social values and morals have their space and are not above constitutionally guaranteed. One of us, Chandrachud J, recognize the right to choose a partner, the important facet. The choice of a partner, whether within or outside marriage, lies within the exclusive domain of individual. Intimacies of marriage lie within a core zone of privacy which is inviolable. I want to repeat this line. Intimacies of marriage lie within a core zone of privacy which is inviolable. The absolute right of the individual to lose a life partner is not in the least affected by matters of faith. Social approval for intimate personal decisions is not the basis. So, majority is not the basis. It is my right. If it is the right, my lord, of the heterosexual group, I would respectfully submit. It is jolly well, my lord, our right, because we are, my lord, equal human beings entitled to the benefits of the Constitution in the same manner as anybody else. Then, my lord, the judgment in Shafin Jahan delineated a space where an individual enjoys the autonomy of making intimate personal decisions. The strength of the Constitution, therefore, lies in the guarantee which it affords that each individual will have a protected entitlement in determining a partner, choice of partner, share intimacy within or outside marriage. We are talking, my lord, of within today. Outside, my lord, in any case is available. In furtherance of the Rawlsian notion of self-respect, your lordship may see, my lord, last 4 lines of this para, just above platism G. This institutionalized expression to love must be considered as an important element in the full actualization of the ideal of self-respect. Social institutions must be arranged in such a manner that individuals have the freedom to enter into relations untrammeled by the binary of sex and gender and receive requisite institutional recognition to perfect their relations. Therefore, my lord, when I say I request for a declaration that we are married, we have to be married under this act, and the state will recognize and register. That, my lord, will be requisite institutional recognition, which will, my lord, follow from the court's declaration of the law under Article 141 and include, my lord, their acceptance, which will be followed by the acceptance of society. My lord, society accepts what the law is. Sometimes the law takes a lead, and I gave your lordship the example of Hindu widows' right to remarry act, which came in the 1800s. There's law acted with alacrity. The society was not ready. It's not ready, my lord, even till early 1900s. Widows remarriage. There, the law acted with alacrity. Here, we need, my lord, to push the society, to acknowledge us as equals in all respects, because the Constitution says so. And the moral authority of this court, it is not only legal authority, my lord. This court enjoys moral authority. It enjoys public confidence. Judgments of the court and the wisdom and the prestige of the court depends on public confidence. The public has confidence in the court. It's not a case where the public has no confidence, but they are bound to follow only because, my lord, there is a decree of the court. The decrees will be violated by people if people don't have confidence. So, my lord, we rely on the prestige and the moral authority of this court, apart from Article 141, that when the highest court of the land has said that there will be no 377, that you will have a right to marry, that there will be no discrimination in public places. It is that, with great respect, my lord, whether Parliament follows it up with the law or doesn't follow it up with the law, that is what will drive the society in times to come, 2 years or 5 years, whatever it be, to accept this group as a fully homogeneous group with their differences and diversities within one whole. As Justice Bhatt used the phrase, not one whole. That's how, my lord, that's what we are looking at.
They want us to settle.
My lord, my friend is right in saying, our parents have by and large accepted us. We are outside the closet.
Process.
So we have gone through the process with our parents already, who belong to an earlier generation, to whom it was not the norm as we understand, because the closet was not opened 50 years ago. They have accepted.
To settle.
They want them to settle. They want them to have a family. They want them to have the same recognition, my lord. They don't want them to be ostracized. That the children are ostracized and the parents are ostracized. Oh, you have children who are not normal. So the ostracism will reach there also. It may reach their close friends. All that, my lord, has to be wiped out. If the constitutional goal of the preamble, as reiterated by this court in Nalsa, Puttuswamy and Navtej, my lord, have to be given full effect.
These petitioners, their parents.
My lord, in my case, the first case, the ceremony was conducted by the parents, my lord, 10 years ago. So they also, my lord, went through some kind of transformation or whatever you may call it.
By more people.
Yes.
Yes,
And they had a reception in their
they had a reception.
in their hometown.
They had a reception. Some people, my lord, I have read, because you can't get married here, they go abroad and get married, get a certificate from there. So there are all kinds of, my lord, situations.
It's a small town, 30
Yes, this was a small hometown. Yes.
30.
Then, my lord, now, my lord, something very important. Kindly turn, my lord, to para 553. There is, my lord, in Justice Chandrachud's opinion, a huge discussion of foreign cases, but para 553 is, my lord, US versus Windsor relating to DOMA, which I had given in their chart. So that description is here, my lord. It's important to read that.
Because Nepal, recently 2 weeks ago, another judge in Nepal has come with translation by tomorrow.
Only one more thing, my lord. Mr. Kirpal tells me just above 551, there is a reference to Nepal, my lord.
Yes.
There is a reference to Nepal just above para 551.
What is that? Sunil, some Sunil.
Yes.
Sunil Babu Pant.